Hi everyone, this is Pennsylvania attorney Evan Gutman with video number 5 of my legal education series on the licensing power to become an attorney and the good moral character requirement for admission to the bar in order to receive a law license. The education series and my videos are based upon my book, State Bar Admissions and the Bootlegger'S Son. The full book, along with a supplement I wrote, is included on either of my two websites, or both of my two websites, I guess I should say, which are heavensadmissions.com and gutmanvaluations.com. Those websites also include a supplement to the book, as well as a fictional novel that I wrote titled Heaven's Admissions Process, which is a somewhat comical and humorous novel that compares the criteria of being admitted into heaven with the criteria for receiving a law license as regards the good moral character requirement. Now, here's the topic of today. The title of my book is State Bar Admissions and the Bootlegger'S Son. What is this thing about the Bootlegger'S Son I came up with? What is the Bootlegger'S Son about, and why does it even have a place in the title of this book, and why is it important? Well, the Bootlegger'S Son is based upon an article that appeared in a magazine which is titled The Bar Examiner, published by the National Conference of Bar Examiners. It was in the first issue of the magazine in the year January 1932. Now, it was presented as a hard nut for character committees to crack because it's supposed to be debatable whether this individual should have been admitted to the bar or should be admitted in the bar, and it's hypothetical in nature. The magazine is published by the National Conference of Bar Examiners. They didn't exist until September 16, 1931. Prior to then, the ABA was trying to gain control of the licensing process for the benefit of the state bars. In other words, the state bars would have direct power over the license process, with the ABA trying to help them along. The ABA itself did not come into being until 1878. Now, I'm going to present more about the history of the attorney licensing process itself, but for purposes of this video, all you need to know is the ABA came into existence in 1878. Its first goal was to wrest control on behalf of the state bars of the licensing process for attorneys. The ABA itself was designed, although they would refute this, I assume, but for all intents and purposes, the ABA was politically designed as a force to ensure the power, stature, and privilege, as well as economic well-being of attorneys, in my view, at the expense of the rest of society. But once again, they would refute that. But they had to first get control of the licensing process because at that point in time, it was questionable as to whether attorneys should be licensed by the judiciary branch of government or the legislative branch of government. As many people as you may know, virtually every single profession other than attorneys, the individuals are licensed by an agency that is either established by the state legislature or the executive branch of government. The only profession where the judiciary itself licenses the professionals is attorneys. Up until 100 years ago or so, it was very, very debatable and questionable as to whether the judiciary should have that power at all. And there were numerous court opinions, which I'll go into in later videos, where it was determined that the state legislatures had the legitimate power to license attorneys, and it was not within the province of the judiciary. Since then, as a result of the ABA, as a result of the National Conference of Bar Examiners, the judiciary pretty much uniformly is now recognized, at least in today's world, that could change, but at least in today's world, they're recognized as having the power to license attorneys. So now, the National Conference of Bar Examiners is designed to get the licensing power for attorneys vested in the judiciary. It publishes a magazine called The Bar Examiner. the first issue comes out January 1932, and it presents this article titled "The Bootlegger'S Son." Actually, the precise title, the full title of it is "A Hard Nut for Character Committees to Crack: The Bootlegger's Son." It presents facts about the applicant, a hypothetical applicant, and the question is whether he has good moral character or not. So here are the facts about the applicant. A law student who is, and I'm reading this actually from the article itself, a law student who is qualified as far as preliminary and legal education is concerned, has taken and passed his bar examination. He has lived for a long time in a neighborhood where there are many reputed to be engaged in the illicit conveyance, trading in, and sale of liquor in violation of both the state and federal laws. His father has been arrested and pleaded guilty to the sale of intoxicating liquors and paid his fine. A relative of the family, living in the same house, has been arrested, indicted, and tried for the illegal sale of liquor. Another immediate relative of the family has been arrested for the sale of liquor, and he and his wife are reputed to be running a speakeasy at the present time. This was, by the way, during the time of Prohibition, when you were not allowed to have alcohol. So the question is posed under these facts and circumstances, and having no further information, should his character qualifications be deemed sufficient to admit him to practice law? In other words, the concept is the applicant's never been arrested. The applicant never broke the law. He hasn't violated a law. He hasn't been convicted. He hasn't been arrested. But a lot of people in his family have. So should the fact that he's got a lot of friends and family members that have been arrested and convicted, should guilt by association be imputed to him? That's in the January 1932 issue, which does not present an answer to the question. However, the very next month, in the February 1932 issue, a proposed answer is presented, and the proposed answer indicates that he should be denied admission. And the proposed answer reads as follows, and you may want to reflect back upon the prior video I spoke about regarding whether the practice of law should be regarded as a right or a privilege, because the proposed answer to this question in the February 1932 issue begins, "He seeks a privilege, not a right." And that's notwithstanding that Ex parte Garland in 1866 clearly indicated the ability to engage in the practice of law as a right. Not all, and then the answer goes on as follows, "Not all candidates who are qualified need be admitted if the court feels that there are too many attorneys." In other words, the concept being, if we got too many attorneys and as a result they're not making enough money, then maybe we should have fewer attorneys. The answer continues as follows. The written answer that's presented by the NCBE in the Bar Examiner magazine of February 1932 continues as follows. "Inheritance and environment are generally conceded to count much in the formation of character. They are among the best tests we have in regard to the young man. These facts being so, I feel that in the case set forth by your correspondent, the inheritance and environment are bad. The contact of the youth with continued violation of the law, especially in his own home and among his relatives, is such a detrimental force and so inclined to shape his view of right and wrong as regards the administration of the law that he is unworthy of trust or of the certificate of reliability to be issued by the Supreme Court assuring the public that he is fit to practice law and to be trusted by them. I am of this opinion, even though the individual has not thus far, in his short period of maturity, shown a tendency to moral delinquency." So the concept is basically, this guy did nothing wrong. He may be the most honest man in the world, or woman, and they don't care. The fact of the matter is that he's got family members and friends who are engaged in breaking some laws and have been arrested or convicted, is enough to deny him a law license, even though he has not yet been shown to have broken the law in any manner whatsoever. That's pretty much the way the state bars look at it. They basically don't care about objective standards. A lot of the beliefs and attitudes that are included in the analysis of the Bootlegger's Son in the Bar Examiner magazine back in 1932, a lot of it still exists today. And that is a key objection I have to the manner in which attorneys are licensed. It's based upon subjective analysis. To make this point perfectly clear, Adolf Hitler, widely recognized as the most evil person ever. Adolf Hitler believed that good moral character consisted of exterminating Jews. He literally believed that. And what's particularly interesting, which I will also go into in future videos regarding the Bar Examiner magazine, as incredible as it seems, in the 1930s, Adolf Hitler is specifically mentioned in the Bar Examiner magazines in a quite favorable and quite positive light. So we'll go over some of those quotes, which are really quite incredible, in future videos. I hope you enjoyed today, and we'll see you within the next day, 2 or 3, whatever, shortly. And remember, love right, don't fight. Bye.